Your Honor. Your Honor, I would like to mention item number 1 for adjournment, Your Honor.
Which was something? What's your good name?
S. Rahman.
Pursuant to the order dated 19/05/2020, registry received the relevant records from the concerned foreigners tribunal. Issue rule returnable by 6 weeks. Right. Mr. R.K. Devsutri Lanet, Deputy SGI, for the response number 1. Mr. A.I. Ali, Standing Council Election Commission, for the response number 2. Mr. Zay Pine, Standing Council Home Department, for the response number 3 and 5. As well as Mr. R.K. Talukda, Government Advocate Assam, for the response number 4. Received notice on behalf of the concerned respondents. The respective respondent, petitioner shall serve requisite extra coverage to them on or before 25/04/2024, obtaining the necessary written acknowledgement from them in that regard. Petitioner shall take steps for service of notice on the response number 6 by register form on or before. Subject to taking steps on the respondents as directed above, and on compliance of the order dated, and subject to compliance of the order dated 19/05/2020 passed earlier. Petition. The petitioner shall not be taken into custody and shall not be deported from India. However, next, further, the petitioner shall not leave the jurisdiction of Superintendent of Police Board or Borpeta without prior written consent from the said authority. And further, and also shall submit for the address before leaving the jurisdiction of Superintendent of Police Board or Borpeta with its consent. However, it is made clear, if the petitioner did not fulfill the direction given on 19/05/2020 and comply with the specific directions therein, the Superintendent of Police Borpeta or Border Borpeta is at liberty to take appropriate action against the petitioner. Okay. Registry shall retain the relevant records received from the concerned foreigners. Yeah, both the registry shall list this matter for according to it to be fixed by it.
Observation.
My Lordship, the petitioner has been declared foreigners by the Learned Tribunal, Karimganj, by the ex parte judgment dated 11/4/2021. The impugned order is at page page 52. Lordship. I beg your pardon, 55 page. 51. It's the ex parte judgment. The tribunal held that after receiving the notice, he was absent. But Lordship, he was completely ignorant of the ignorant of any notice was served upon him. So he just came to know about the notice on 29/11/2018 when the police personnel chased him. That time he only came to know.
Take your seats. Yes. Mr. Pine. First, see the notice. That green mark. It was signed on 11th of September, probably.
Yes.
No, 11th of November, 2020. Fixing the date for appearance on 3rd of January, 3rd of February 2010.
3rd of February. Third
Now
of
turn the page, the notice. Down below, you'll see when the in charge of Nilam Bazar outpost forwarded it to the tribunal.
8 to 10 months.
It appears to be 8/2
Yes.
after the date. But no fresh notice was issued hereafter. Right? It may be 3rd of February or maybe 8th of February, whatever,
Yes.
right? But the tribunal did not issue any fresh notice. From the records, what we found that there is no such reference. Maybe that page is missing because earlier it was under the IMDT Act. But why it was under the IMDT Act, that is also we do not know. It was in 2009 the proceedings started. It has come back to the Kokrajhar Furnace, Karimganj Furnace Tribunal sometime in 2009. Maybe that is the reason. But when it was forwarded by the Superintendent Police Order, Karimganj, normally it will not be. Nilam Bazar is just see the first page of the order. There you'll see this first page of the order. That is this present case.
Yes.
That will refer to the Karimganj Furnace Tribunal number 3. Because Nilam Bazar comes under the jurisdiction of the that foreigners.
Putable, maybe my lord, but my lord, the dispute whether he put signature or not.
That is different.
That is a different thing.
That we are not on that. But
Yes.
from the notice itself, you can see.
Yes, from the notice itself, it shows, my lord, probably the notice was not properly served. So your lordship may remand it. That even sounds.
RMS J. Paul, counsel appearing for the petition. And Mr. J. Pang, standing counsel, Home Department, some for the respondent number 2 and 6. Also heard Mr. A.I. Ali, standing counsel, Election Commission of India for the respondent number 3. As well as Mr. R. K. Talukdar, Government Advocate Assam for the respondent number 5. The J. Pang, 6 and 7. 3, 6, 2, 6 and 6. On a reference being made by the Superintendent Police Board of Karimganj, under section 2 within bracket 1 of the Furnace Tribunal Order 1964, seeking an opinion as to whether the petitioner is a foreigner or not. The Foreigners Tribunal number 3, Karimganj, on eleven 2009 in FT Foreigners Tribunal number 1. Case number 615/2009, within bracket like P.E. number D/5877/19. Issued notice to the petitioner in the address Kanu Roy, son of Chittaranjan Roy, village Alangkhani, ALA and KHANI. While memo dated 13/11/2009. Enabling the petitioner to submit his written reply as required under the provisions of the Foreigners Act 1946 and Foreigners Within Bracket Tribunal that it was order 1964. The tribunal came to the finding that the notice was served upon the petitioner and in spite of that he remained absent without any steps. As such, by order dated 11/04/2011, that's just on 11, by an ex parte order on 11 by an ex parte order, the Foreigners Tribunal number 1, Karimganj, opined the petitioner to be a foreigner under the Foreigners Act 1946 as he failed to discharge his burden under Section 9 of the Act 1946 Act. It is stated by the petitioner that he was not aware of the said order of the Foreigners Tribunal as notice was not served upon him. And he came to know about it as he had to inquire why police seized him. On coming to know about the said ex parte order, dated 11/04/2011, passed by the Foreigners Tribunal number 1, Karimganj, declaring him to be a foreigner under the Foreigners Act 1946. The petitioner on 02/04/2018 submitted an application under Order 9, Rule 13, read with Section 151 of the Code of Civil Procedure, for setting aside the said ex parte order of the tribunal before the said tribunal. before the Fairness Tribunal 1, Karimganj. Stating that he was unaware of the notice, unaware of the proceeding initiated against him before the said Fairness Tribunal, as notice was not served upon him. Notice of the said application. Along with the said application under Order 9, Rule 13 of the CPC, the petitioner also filed an application under Section 5 of the Limitation Act to condone the delay in filing the said application to set aside the ex parte order dated 11/04/2011. Since the case of the petitioner falls under the jurisdiction of the Nilambazar Police Station, the London member of Fairness Tribunal, London member of Fairness Tribunal number 1, Karimganj, by its order dated 05/02/2018, made a request to place the matter before the Fairness Tribunal number 3, Karimganj, being the jurisdictional authority. And accordingly, the said application of the petitioner filed under Order 9, Rule 13, read with Section 151 of the CPC, filed on 02/02/2018, along with the condonation application filed under Section 5 of the Limitation Act, was the same ex parte order dated such and such part by the Fairness Tribunal 1, Karimganj, was placed before the Fairness Tribunal number 3, Karimganj. During the deliberation of the matter, when it was pointed out before the Fairness Tribunal, when it was pointed out to the petitioner by the Fairness Tribunal, showing the signature of receipt of notice by him by putting its signature, the petitioner argued that he usually gives his signature in the vernacular, put in bracket, Bengali. But the notice was received by one Kanu Roy by putting his signature in English. The London Fairness Tribunal number 3, after hearing the submissions of the petitioner, being not convinced, by order dated 02/07/2019, rejected both the petitions of the petitioner filed under Order 9, Rule 13, Radio Section 151 of the CPC, to set aside the ex parte order dated 11/04/2011, passed by the Fairness Tribunal number 1 in FT case number 615 of 2009, as well as the condemnation petition that he filed. Aggrieved thereby, the petitioner filed this writ petition on (19 12/2019). By order dated 19/05/2020, the record of said FT case number such and such 615 was called for from the Fairness Tribunal number 1/Fairness Tribunal number 3, Karimbganj. On perusal of the records of the said case, we found that the Fairness Tribunal number 1, Karimbganj, only that notice to the petitioner was issued by the Fairness Tribunal number 1 on 10/11/2009, fixing the appearance of the petitioner on 03/02/2010. On 03/02/2010, the tribunal awaits for the report till fixing 06/04/2010. On 06/04/2010, the tribunal received back the notice but found the petitioner absent and accordingly fixed 01/07/2010 for written statement of the reply of the petitioner. On 01/07/2010, paragraph 43, the petitioner was found absent by the tribunal and fixed 08/09/2010 for necessary order. On 08/09/2010, the learned member was absent and accordingly matter was fixed on 03/12/2010. On 03/12/2010, the petitioner was found absent by the tribunal and accordingly fixed 16/02/2011 for necessary order. On 16/02/2011, the tribunal again found the petitioner absent without any steps and fixed 11/04/2011 for ex parte hearing. On 11/04/2011, the tribunal came to the finding that the notice was served on the petitioner, and in spite of receipt of notice, he remained absent without any steps. And thereby, he did not challenge the reference, nor took any step to prove that he is not a foreigner. Since the petitioner failed to discharge his burden under Section 9 of the Foreigners Act 1946, the Foreigners Tribunal number 1, by its order dated 11/04/2011, passed in said FT case number 615 of 2009, opined that he is, the petitioner, is a foreigner under D voter strip. But on perusal of the notice from the records of the case, we have seen that the notice was issued to the petition. Notice of the said application number 615/2009 was issued to the petitioner on 11/11/2009, fixing the matter on 03/02/2010, directing him to file his written statement of reply along with the relevant documents to prove his nationality/citizenship. And the notice was sent by a memo dated 13/11/2009. From the same notice, we have also seen that it was received by one Kanu Roy, putting signature in English. With the report of the process server that notice has been served on the concerned noticee in the address specified in the notice. But no such signature, no such date was found of receipt of the notice by the concerned signatory, concerned recipient, nor by the concerned process server. Rather, we found that the in charge of Nilambadar police station outpost, to which the notice was served upon the alleged proceeding, was returned to the tribunal on third or 8th of February 2010. Command here. Full circle. Third, no, 8th. From the date given in the said notice by the in charge of Nilambadar police outpost, it cannot be ascertained whether it is 3rd February or 8th February. From the order sheet of the Furnace Tribunal number 1 in of said seat FT case number such and such, it is also seen that the tribunal did not issue any fresh notice to the petitioner pertaining to say FT case number 615. Mr. Pai, learned Standing Counsel, Home Department, on perusal of the records submitted, that whether the notice was served on time to the petition, it cannot be asserted. That was issued. The notice of the notice to the petition was issued by the tribunal on 11/11/2010. It cannot be asserted. Leaving aside a dispute, of receiving the said notice by the petitioner by putting his signature in English. After hearing the land counsel for the parties and the submissions made by them, we are of the opinion that the notice of said FT case number such and such issued by the Foreigners Tribunal number 1 Karimganj was not duly served upon the petitioner as required under Order 3 within bracket 5 of said 1964 order, as well as the law laid down by the Honorable Full Court in the case of Muslim Mandir reported in. According, we set aside the impugned order of the Foreigners Tribunal number 1 Karimganj dated 11/04/2011, passed in the FT case number 615 of 2009, as well as the subsequent orders dated 20/02/07/2019, passed in Miss case number passed by Learned Foreigners Tribunal number 3 Karimganj in Miss case number 12 of 2018, whereby the tribunal rejected dismissed the application filed by the petitioner under 9 Rule 13 dated section 151 of the CPTC to set aside the ex parte order dated 11/04/2015, as well as the condonation petition filed by the petitioner. Condonation petition filed under section 5 of the limited to condone the delay in filing the said application under order 9 Rule 13 and uphold the order. Rejecting that. Since the petitioner is aware of the proceeding initiated against him under the Foreigners Act 1946, he is directed to appear before the Foreigners Tribunal number 3 Karimganj on 15th of May.
Yes.
Okay.
And on the same day, the petitioner shall file his written reply of the statement along with the relevant documents as to whether he is an Indian or not. As per foreigners to prove his citizenship, nationality of it. On the state date, the petitioner shall appear with certificate of failure on the part of the petitioner to appear before the Foreigners Tribunal number 3 Karimganj in such and such on such and such and file his written reply. And the said tribunal shall be at liberty to proceed against the petitioner in accordance. We have over this generation, this petition stands allowed to the extent that the registry shall return the records to the records of the Foreigners Tribunal number 3 Karimganj along with a copy.
Bless Lordship.
P. James Freeman. Not treated. अपना तो नहीं अपना
Issue rule returnable by sections. Mr. Rakhi Dev Chaudhary, Learned Deputy SGA. For the respondent number 1. Mr. J. Pang, Extending Council Home. For the respondent number 2 and 6. Mr. R. K. Talukdar, Government Advocate Assam. For the respondent number 3. And Mr. A.I. Ali, Standing Council Election Commission Committee. For the respondent number 4. Accept notice on behalf of respondents. Concerned. Petitioner shall petitioner shall serve requisite extra copies to certain sentences on or with 25/04/2024 of the Indian. Petitioner shall take steps for service of notice in the respondent number 5 by registered post with for making its correct and correct on or before 25/04/2024. Registry shall retain the records of application number 1504 in the first call by order to 2005. Subject to the compliance of the order to the 2005 interim order. 520. The same will remain in force until further order. However, it is made clear if the petitioner did not comply with the said order, the 2005, the Superintendent of Police order for that shall be at liberty to do the needful in accordance with law. But if you object, Registry is the map on a date to be fixed. Same order. But Mr. Rajat. For the petition. 1 RTF to 3. 2 4 Z Sharma, Standing Council Home Department. 3 Article the Superintendent Police Board. Application number. Finance Tribunal. Interim order 2005. We have issued rule to take steps. Or like.
May I please, my lordship, the matter may be adjourned for today as my senior is out of station for election.
What's your good name?
M. Sahu.
Or MSM Sahu, counsel appearing for the petitioner. And Mr. Z Sharma, standing counsel from Department of Sound for the respondent number 2 and 4. Also heard Mr. A.I. Ali, standing counsel, Election Commission of India for the respondent number 3, 5, and 6. The reference being made by the Superintendent Police Board and Sunil Good. Learned Corners Tribunal, Bishanath first, Bishanath Chariali. In case number ENC/D/108/2016. After hearing the petitioner and other parties, by its final order dated 15/12/2022, opined the petitioner to be a foreigner under the Foreigners Act 1946. Who had illegally entered into the territory of India in Venkatastaram on or after 25/03/1971 without any objection. Aggrieved by the said opinion dated 15/12/2022, the petitioner filed a said petition on 10/04/2024. After more than 2 years. Kolpate records with the correct registered them correctly.
May please your lordship, my lord, apart of the merit of the case, my lord, we have taken the ground, my lord, having two charge in the notice. My lord.
We'll come to that. Mr. Pai, yesterday there was an issue, you are not there.
Yeah.
Mr. Sigdar argued the case that in the notice, there was no such specifications as to whether the petitioner is from 1960 to 1971 of March or thereafter. So two charges are there. Placing a case of Asia Khatun, right?
Yes, my lord. Amina, my lord, it's Amina Khatun.
Amina. Now, Mr. Payang, what we found from the reading of the Foreigners Act 1946, the Foreigners Order 1964, and the Muslim Mandal, since there is no IMDT, no proceeding is in the RAM, question of those two streams after the judgment of the Surrender Sonwal 1, issuing notice in a specific form doesn't arise because the Act of 1946 and the orders of 1964 is very clear. If you read the order 2 of the 1964 order, the central government or agencies authorize import only to seek an opinion whether the person concerned is a foreigner or not. That much.
Yes.
Now, it is only the tribunal when the matters will come before the tribunal, and after the tribunal, considering the evidence adduced before it, will determine that the particular proceeding is of a foreigner of this period or that period.
Yes.
How the tribunal, without going through the evidence to be adduced by the proceeding, will come to a finding at the very beginning, at the time of issuing notice itself, that you are a foreigner of this stream or you are a foreigner of that stream. Is it possible? Somehow, what we found, that particular decision that he has placed before the court, if you read that entire order, comes to those annexure A and B of the IMDT Act.
Yes.
But entire proceeding of the IMDT Act,
Has been satisfied. So all those two form has also been
see,
satisfied.
that is what we found. Nobody has placed. See, petitioners who have been declared to be a foreigner will always be happy to have that opinion. But what is the Act and the order says? Even the Muslim Mandal judgment, full court, if you see. So you just, what we were reading in these provisions, we tried to found that it is the basically in the Foreigners Act, there is no such possibility of making it is only in the Citizenship Act amendment after 6A. Question is, the proceeding is done under the Citizenship Act. Proceeding is under the Foreigners Act. So only at the time of finally,
Yes, final
tribunal will
decision,
come
my
to
lord.
finding the
Yes.
concerned proceeding is
Then he
foreigner.
can give an
And if
opinion.
it is a foreigner of which stream?
Which
And if he is a foreigner of the stream from 1960s, then he has an.
you will register. That
That's
is
all. But how come these submissions are coming that there are these two things are come? Foreigners Act, the orders doesn't say anything in that regard.
My lord, the Foreigners Act 1946, my lord.
we should do.
See,
There
order
is
two.
nothing mentioned or how
That
the
is why
methodology, what is the methodology of identification?
What is a foreigner? Foreigner means, if you read that act,
My lord, there should be some method of identification.
that is why.
There is nothing, my lord.
True. See, that is why 1964 order 2 is very specific. Opinion is to be sought for by the
My lord.
concerned authority whether the person is a foreigner or
My-
not. That's all.
My lord.
All these two
Clause
kind of
three,
things
clause
came
three of the
only after
foreigners
the
tribunal.
IMDA Act. Now,
Well-
we are doing something, somewhere way from, at the same time, the report of the LVO, report of the things in the document, that is another issue. It is the opinion of the concerned ERO. The name hasn't figured, he is found to be, he is suspected to be a foreigner, right? So
My
he
lord,
might call for.
My lord,
he might call
suspect
for-
without materials ground is not
Listen,
permitted, my lord. That is the Supreme
That's
Court
what-
judgment, Sarvanda Sunwal.
true, that's what we have to read.
And the
those-
clause three of the foreigners tribunal order specifically said there should be a material ground of suspect.
that
What is the
why-
ground of suspect?
That is the reason why the full bench the full court have clarified. If there is any doubt on the mind of the tribunal, it can return back the matter to again, the opinion seeking authority, the Supreme Police Board, to clarify. That is the reason, simply it cannot be a rubber stamp that you have received and sitting in a certain reference, you just issue notice. That is not the case
Yes,
of the
ma'am.
foreigners tribunal.
Ma'am.
Foreigners tribunal at first have to ascertain.
Yes, my lord.
Right. But thing is this, these two periods will come only after the determining taking the evidence. At the beginning, it
No,
is
my
not
lord.
possible.
My lord, before trial, the evidence in the before the trial, the full bench clearly said there shall be a fair investigation and to ascertain the grounds of suspect. And the paragraph 98 said there shall not be mechanical reference. That means some materials to be produced, my lord. Based on that materials, the tribunal is to specify.
that particular judgment on the basis of the reference was made to the full court. See that particular judgment, from where the reference was made to the full court. Again, the goes to notice under the IMPT Act. When the IMPT Act is no longer in force, but
That's-
entire decision, if you, that is the reason we are asking you, you are
My
the
lord.
court officers,
My lord,
pocket departed, you are parting for some particular respondent or petitioner.
my lord,
You are the court officers.
my lord.
You read that original judgment that was referred to the full bench. It's a matter of the IMDT Act. Notice been issued. The inquiry was made under the IMDT Act. What is the question of IMDT Act?
Yes, my lord. That I agree, my lord.
Then,
My lord. That I
because
agree.
the entire decision, the discussion made on the basis of those grounds.
Yes, my lord. That is also, my lord, irregularity, my lord.
Absolutely. When there is no such part was there available in the Foreigners Act,
Yes, my lord.
how can we have that one?
That's
Anyway,
right.
Mr. Secretary will go to that. Mr.
My lord.
Buying these things, you should.
My lord, I have, in fact, in two judgments, it has been differentiated now, my lord. In fact, I argued 2-3 occasions before the Honorable Court also, my lord, that two forms are no more, my lord.
See, if you read one of the judgment, very early judgment of Justice, as he was then looking at. He was considering in 2-3 judgments. First one part was the judgment with regard to the two notices A and B.
Yes.
Number one. With regard to the report of the ERO, Annexer 1 and Annexer 2. Right?
Yes.
So some of the Annexers 1, you will see there is a blank. There is no such, the LVO doesn't make any such inquiry. It's totally blank, but somehow the ERO comes to the conclusion that he is a foreigner. He has doubt.
Yes.
See, in those matters, when the matter was referred on the report of the ERO by the Superintendent Police Board to the concerned Foreigners Tribunal, it is duty of the Foreigners Tribunal to refer back the matter. Send back the matter. You
Yes.
make a proper verification, then you place it.
Yes.
Yes.
That was,
Not done.
yes.
It was not doing, nobody has been suing.
Yes.
Very rarely you will find. Right?
But, in fact, my lord, if I submit, my lord, because those two forms which were referred to the, my lord, LVO, the LVO reports, those are of 96, 97 and of 2005, prior to the judgment of the, my lord, Honorable Apex Court, because those were under IMDT. Those two forms were under IMDT. My submission is, my lord, those are not necessary at all as of now.
How the ERO will
But-
come to the finding
No.
that how they suspect a person to be a foreigner?
My lord, the suspect foreigner during 1997, the ERO issue is a different issue and the police issue is a different issue. When ERO suspects, my lord, when in 1997, during extensive revision, they found that these names are suddenly appearing in the voter list, the suspect arises. That is the basis of suspect, man. Then it was forwarded to
Mr.
the,
Ali, do one thing.
yes, that is the
That you can always place those particular documents when there is a question of extensive revision was done.
Yes, sir.
You have to go back to
There are
those
lots-
cases. And you can always place, because these are the issues which we are always hearing.
Yes, sir.
my
All
lord,
the councils are arguing
Yes,
same
sir.
thing, right? So you can enlighten us by placing those materials on what basis?
Yes, sir.
What was the direction issued
Yes,
when
yes.
the extensive,
And the intensive,
This is done.
I have placed Yes. on, I'll again place it, Your Honor, on Monday I can place it. Because the intensive revision took place on twice, on two occasions, no? One on in the year 1997, day after on 2005, Your Honor. Subsequent to that, whatever D was marked, Your Honor,
no, that is the reason. On what basis the ERO comes to a
on the
finding?
basis of the LVO report, Your Honor. That was, but,
Yes.
but there are
My lord.
certain facts, Your Honor. In certain LVO report, we have seen that the petitioner claims that LVO has remained various columns blank, Your Honor. But Your Honor, certain circumstances have come arise, Your Honor, where we can see that when the LVO approaches the person concerned for investigating the fact, they are not able to produce any document, Your Honor.
That we know.
That-
So
that's
I
why,
belong to a particular village, I know.
yes, sir.
So I know what
so the
many
columns
things are
remains
things
blank,
that-
Your
that
Honor.
is Mine we will not
Yes, yes,
do.
sir.
Yes.
Because
We
they
can
neither
just
furnish
clear
the
in the court
facts,
of law.
nor they furnish any documents. So as such, the LVO has to return back, leaving the columns blank, Your Honor. And the allegation comes that the LVO is not going to the places or he is not. So on certain occasions, when the LVOs are smart enough, they used to write on the side, on the corner or the year report that no
Just in
documents
one of the
furnished.
case
Yes, sir.
which you have disposed of. That is on the basis of the report
Yeah.
of the ERO.
Yeah.
my lord,
ERO sent notice. There's a very interesting page we found here, those who have disposed it of. ERO sent notice to the proceedee. Proceedee did not appear. Then the reference was made to the Superintendent Police Border, Karimganj.
my lord,
ERO
the
sent
proce-
notice, fixed a date, did
Yes.
not appear.
my lord, the process
Well-
is, my lord, may I submit the process. Once the ERO sent the matter to the LVO for verification, because once it is suspected by the ERO, my lord, it is sent for verification by the LVO. If LVO give a satisfactory report that yes, his name is there, he is so and so, he is so and so, then ERO can continue his name in the voter list. That's why, my lord, it is in fact in numbers of judgment, this honorable court has clearly said this if LVO, my lord, cannot give a satisfactory report, the LVO will have to send the report matter to the, my lord, foreigners tribunal for reference. If he is satisfied on the basis of LVO report that yes, his name can be continued in the voter list, his name can be continued in the voter list, then it may not be sent to the foreigners tribunal. That is the process, my lord. That is the law and that is settled.
Kindly give us those citations
Yes.
in where.
My lord,
it has been
citations are
One
there.
is, Your
Quran Ali.
Honor, Siamuddin.
Siamuddin, Siamuddin.
WBC 91 of 2019.
And that was,
That is ordered at 19 February 2019.
It is under challenge.
No, yeah,
That was challenge in the
writ
consultation.
appeal. Writ appeal has been upheld, Your Honor. That's ordered. The writ appeal is writ appeal number 170 of 2019.
Now, whatever those about the proceeding that two charges talking about.
two surges, my lord, I have judgment.
Sonakha case, my lord.
I can produce just,
91. Mr. Ali, it is 170. read
One
it.
is 170, writ appeal 170 of 2019, Your Honor.
WP.
And
and
the petition is
WPC
91.
91 of 2019.
Okay.
In fact, Your Honor, after 2005, the election commission has marked D only on the basis of the judgment passed in Momeja Khatun just case, Your Honor, wherein the honorable court has held that not only the persons who were marked as who were found as during the intensive revision, but also every person
Momeja
against
Khatun.
Momeja Khatun. I'll provide you.
WBC number?
I'll-
Give it to us.
Yeah,
Just find out.
it was there after that by this honorable court, even in the division bench also, that if a person has been marred, any proceeding is initiated against a person before the foreigners tribunal, even they should not be allowed to vote, and the foreigners tribunal should send the record to the ERO election department, and they should mark them as D. And once the foreigners tribunal gives an opinion, after that, if he is declared an Indian, the D should be removed, and if he is not declared a foreigner, he should be name should be declared deleted from the electoral roll.
For next, my lord, the another judgment.
Well, a guideline relating to the extensive revision of the
We'll come
voter
to
list.
that.
That is also important, my lord. My friend can
That-
also.
That is
produce it.
there, my
Even
lord.
that
already.
guideline
That
was
guideline
challenged,
was
Your Honor,
challenged.
in
That
the
is.
case of HRS Chaudhary versus Union of India.
That's right, that's right.
Apex Court has
That
upheld
was
the
challenged.
guidelines of intensive revision.
That was a challenge, already law is.
Yes, law is
established
settled.
there.
That
But
is.
some paragraph maybe
Everything was
refresal of some
considered-
paragraph is
Everything
necessary.
was considered. That is why they are under challenge.
Yes, that was.
Go to the
specific.
records of that case, you'll know everything.
Then, my lord, Rukia Begum Borhuya, it is WPC number 2279 of 2021.
WBC number?
2279
Yes.
2021, my lord.
Ah.
Rukia Begum Borhuya. It's order dated judgment dated 12/06/2023.
21, no?
This is one and another one.
That is some faulty reference, my lord. Whether because
Guidelines are all over the very much of this work. But the evidence.
Yeah, look into it.
Yes.
Look into it.
Mallowa Nathiri.
We're just making it clear for you that
Yes.
next time when these issues will come,
Yes,
because
yes.
this is another case where it's, I mean, you should make it clear.
yes, your lordship can settle this issue, my lord, in a particular case because
Should be because,
Yes. because
Mr.
this is
Sikdar is also aware of the fact that, after the IMDT Act gone,
yes,
notice cannot be on the basis of those two charges. It has to
Yes.
be under the Foreigners Act.
there is no provision of 6671 stream, my lord, in
It is only
foreigner.
under the Citizenship
Foreigners
Act.
Act.
My
Only
lord,
those in evidence.
My lord, the main principle is my lord, to decide what is to be decided, my lord.
Yes, whether
That
he
is whether he is a
Exactly.
foreigner of
foreigner.
471 or his stream.
Absolutely, see.
So
Same question will come when,
there-
after evidence.
Yes,
The act is very clear. You read the statement and objection reasons of the Foreigners Act, then you will come to know. See, basically, the person is a foreigner or not, he has to be established. At that point of time, of
My lord.
which stream doesn't arise.
my lord, in a criminal case, my lord, Khan is better expert in this line. In a criminal case, but police has submitted a charge sheet. Then before trial, court is also framed charge. In the same manner, in this case also, the
Don't
Police-
compare it to the criminal
police
case.
or the ERO make a charge.
that is
How can
not
we
the
have
law
a
here, my
criminal
lord.
CRPC here?
That is not
My
the
lord,
law here.
therefore, the Supreme Court in Sarvanda Sonal case said that the owners of the state is to be discharged fast.
No,
That is the charge. In
Anyway,
fact, the
heard Mr. Yes, the council appearing for the petition. And Mr. J. Prime Standing Council from Department and Sam for the respondent for 2, 4, 2 and 4. Also heard Mr. Peter Luther, Governor of Assam for the respondent 3. Mr. A.I. Ali Standing Council elected. Reference being made by the Foreigners Tribunal, sorry, Superintendent Police Porter Golpara. The Learned Foreigners Tribunal number 1 Golpara in application number 8371 of Z of 16. After hearing the parties by its opinion dated 15/03/2023, opined the petitioner to be a foreigner under the Foreigners Act 1946. Who had illegally entered the territory of India, Assam.
The foreign. As you fail to establish her. As you fail to discharge her burden under section 9 of the foreign sector. The foreigner and the foreigner seem to know. Dissatisfied with the said opinion that at 15/03/2023 foreign establishment. The petitioner filed this petition on 10/04/2024. Issue rule with an evaluation as Mr. Sachin said, one legal. Deputy. 2 and 4 by 3 by Mr. 5 by no problem. Depth by 25th of petitioner shall be accepted by register. Call for the records of Bucky. It will not call for the records. Call for the records of and register this immediately. Reciprocal list on. To 28th of May.
Yeah, please, Your Lordship. I want adjournment today, Your Lordship. For 2 weeks, Your Lordship, I have to obtain some instruction.
Administrative issue rule returnable by secretary. The list to receive the relevant records of the case from foreign tribunal number 10. Person case are problem. Subject to the compliance of the interim order 22/11/2017. The petitioner shall not be taken into custody and deported immediately until further of the. However, if the petitioner did not comply with the said order, the Superintendent of Police order result. Necessary action. Petitioner. Shall appeal before the Superintendent of Police order. To bring. Shall not leave jurisdiction. It shall list this matter according on the date to be fixed.
Obliged.
Make me one more.
Application is allowed with cost of rupees 3,000 to be deposited in the DLSA of Bongaigaon. And then one opportunity is afforded to the applicant to appear before the DLSA with the receipt of the payment and yes,
Published.
oh yes, on 25, 20 May.
20th May.
We'll come back for the other ones. Let us see whether sister has arisen or not. Borua. Information to Lahore by road. Lahore. We'll come back immediately. Wait for some.
The Lordship. Lordship, I beg to mention item number 3, Lordship. 3,
3.
3, Lordship.
This is with 2.
Yes, Lordship.
1 3 goes means 2 have to go.
Lordship, kindly item number 3 may be heard after 2 weeks, Lordship.
Why?
Lordship, Senior Advocate Mr. H.R. Chaudhary and Mr. F. Bodri, and they both are out of station, Lordship.
Why after 2 weeks? If the result is in his favor, then what happens?
Lordship, after 2 weeks, Lordship.
All are 1 goes means up to 7.
No, Lord. From 3, 2 to
2 to 7 is one matter.
2 to 7,
Lordship.
1 minute. Wow. It's take
Although
minute.
one
Who is
matter.
appearing for 2?
No,
Your Lordship, my senior Emu Mahmood is on legs. He'll be doing item number.
Lordship,
item
Yes,
number.
Mr. Prime, what do you have to say?
My lord, all these matters are
Now segregate to Lordship. All are different issues, Lordship. The
issues
issues
are
are
different.
different, Lordship.
Only one issue was there, delay problem. The delay was there. That was the initial issue. My lord. For that reason only this were tagged together. Delay in filing the review. Whether the
May I please, Your Lordship, for item number 2 and 7, my senior will do.
Okay. Who is
for this matter may be segregated, matters may be segregated
you are
otherwise.
segregating? That's
Yes.
it. You are also appearing for 4.
No, Your Lordship, item number 2 and 7.
Okay. Who is appearing for 4?
My lord,
Yes,
I may say for item number 4, my
you'll argue now.
I can.
Who is for 5? Mr. Sikdar was here.
Six,
6, who is appearing? Mr. Goswami, you are appearing for which item? Okay.
6 is Bharati Devi, madam.
Okay, we'll adjourn your matter. We'll segregate it, each one. And Yes, four. Let us have it four. Yes, you are mentioning some item?
Item number 9. Adjourn for week.
Okay.
Item number 11, my lord. And that will be taken away any other day, my lord.
Yeah, order tomorrow. Yes, sister.
One,
One.
my lord. My lord, in this case, my lord, the not command.
One.
As I respond, for respondent, is there.
Yes, yes. My lord, in this case, my lord, the arguments, written arguments were filed. Those were in record, my lord, because the arguments were closed and written arguments were filed. Those written arguments. So after filing of the written argument, my lord,
Okay. Heard Mr. J. Pine, counsel appearing for the petitioner state. And what's your name?
Assure.
On behalf of Mr. M.U. Mahmood, counsel for the response. Over. Full respondent. Written arguments have been filed. What are the get the file.
May I please, your lordship? Lordship, in this case, the present petitioner filed his review petition for filing his additional WS and additional evidence in chief before the learned tribunal, my lord. Earlier occasion, my lord, the petitioner also approached before the Honorable High Court by filing a writ petition for filing additional, allowing for filing additional WS and additional evidence in chief. Two cases was filed, my lord. One for the elder brother of the petitioner, and next case was filed for the present petitioner, my lord. But elder brother's case was allowed for filing additional WS and evidence in chief. But case of the present petitioner's writ petition was rejected, my lord. Kindly may peruse that page. Page 68, my lord. The case of the present petitioner was rejected by the Honorable High Court, my lord. Page 68. Operative part will be at page 70. May I read the?
Just a
My lord, review the grounds to allow for filing additional WS and additional evidence is in chief, my lord, which against the order dated
What is the ground of review? The same prayer you have made earlier also,
my
same
lord,
statement of facts that was there.
my lord.
Why you have
But,
filed this?
grounds, the elder brother's case
Can it be a ground?
allowed, my lord.
When the elder brother's
Similarly
case was-
situated case, my lord.
When the elder's case order, judgment order was allowed,
My lord, kindly may peruse that page 65, my lord.
on which date?
Date is 6/9/2018,
And when the case of the petitioner was,
7/9/2018, after
So-
1 week, my lord.
who was the counsel for the petitioner
ARVA, my lord.
in the other case?
Same council. My lord.
So what is the ground of review?
The basic ground is that for equal justice, my lord, the out of 10 days, two occasions, the present OP and his elder brother was present, my lord. Kindly may
Can
peruse,
it be a ground?
my lord, kindly may peruse that page. Page 6 of the review petition, my lord.
Sharma? CPC. Right over. Develop it. CPC. Error report, key error report. Sharma. Read the conditions precedents for a review.
My lord. My lord, regarding this issue,
Kindly read.
my lord, a person of the order so and so rule 1 show that the review of the judgment and or an order could be brought from the discovery of new and important matters or evidence which after the exercise of due diligence was not within the knowledge of the applicant. Number B, such important matter or evidence could not be produced by the applicant at the time when the decree was passed or order made. And number C, on account of some mistake or error apparent on the face of the record or any other sufficient reason judgment stands. This is the relevant.
So which are the ground will come into, tell us, for which reason it should be considered for review?
My lord. First of all, is lordship. At page 38, my lord, kindly may peruse. In this case,
Why that order is need to be reviewed? Can you tell us the reasons for review of the said order?
a review for
passed earlier
the
by the
state
coordinate
order,
bench?
basic issue is that for equal justice, my lord. Kindly may peruse that page 6 for the of the review petition, my lord.
Is 6.
Page 6, my lord.
Yes. Yes.
I have mentioned the dates, my lord, list for FP case number 152 pertaining to the review petitioner, my lord. And in the right column, my lord, for the elder brothers case, my lord. Total 10 date was fixed, and out of 10 dates, 2 dates were present by the present petitioner and his elder brother also. But the present petitioner's case was rejected, and the same grounds and same issue on the same specific dates was mentioned, but the elder brother's case was allowed, my lord. So the present petitioner has approached before the Honorable High Court for the equal justice, my lord, to allow him, because he has not deposed his oral evidence. And another grounds, my lord, during the filing his WS and evidence in SIP, very vital 2 documents, 1971 voter list and 1985 voter list was not annexed, my lord. Without annexing those documents, evidence in SIP of the DW1 was filed. Thereafter, the review petitioner was changed the engaged counsel. Thereafter, new counsel discovered the documents after going through the records that vital documents 1971-85 was not annexed. So, without annexing these documents, the whole case will be baseless, my lord, and meaningless to contest the case, my lord. But this was not comes into the knowledge of the present petitioner by the earlier engaged counsel. But delay was not intentional, my lord. The new Angus Council at page 38, my lord, he submitted the applications before the learned tribunal, my lord. Kindly may peruse page 38 of the review.
Why you have annexed the same set of documents and the annexes on two occasions? Right.
Court, my lord, here is two sets of documents, one for the elder brother's case record and next for the present petitioners, my lord.
It
Same,
is same 152 only.
uh,
You see,
one is 162, present petitioners, FT case number 152, my lord. 152
page
is
number 27 to page number 40,
some of the documents, my lord.
27 to 40. The same again at page number 41 to
Some documents were annexed in the
50. Why?
writ petition, my lord, of the present petitioner. And some sets of documents in the review petition, with the review petition, my lord. Same documents in the writ petition was also annexed, my lord.
Mr. Pai, see, both of us are discussing not in the jurisdiction of the grounds of review.
Yes,
They could have preferred an appeal saying that in the similar circumstances, the dates are fixed, same lawyer has been engaged, petitions filed on both the occasions, both the brothers remain absent. Same technique was used, but in the case, how can we review? At least?
yes,
Does
my
it
lord.
come under any grounds of the review?
There is no grounds at all, madam. They have not set out any ground.
We have also seen that this petition was filed while both the brothers were
Yes,
in the service, right?
councils also same council. And my lord, that is one aspect of the matter. My lord. There is no grounds set out.
Or review of this order.
Yes, for
The good
review.
one might have been an appeal.
Yes,
That could have been an
if they
appeal.
go for appeal.
The parity, otherwise.
Yes. And secondly, my lord, they ordered it, my lord, 5/8/2022 with regard to delay of 524 days in filing this review.
Did he, earlier myself with Brother Justice Medhi, we passed an order, we have
Yes.
considered that time period. Where the judgment of the apex court. Time limit has to be there.
Yes,
In fact, subsequent decision of prior, after this connection, there is another division bench judgment, I think. So,
yes, my lord.
where the time limit is
Time limit is,
enforced.
and in fact, even though they have not filed, my lord, delay condonation petition, that is not even, my lord, they have explained in single words why they have
But
delayed.
a delay in
There is no explanation of delay in election in the review petition. Also.
There is a judgment of the Supreme Court, I couldn't recollect now, long judgment. I just collect it. Let me recollect. Somewhere, if it is, if I'm not wrong, para 45, that's very specifically, the Honorable Apex Court has said, if the contention of the petitioner in the writ petition and the review petition is same, and the writ petition is dismissed on the same ground, whatever contentions taken. The same, on the same ground, they cannot file a review petition.
Yes, that is obviously there in the Kamalesh Burma also. It is clearly said. It cannot be.
So all judgment of the Honorable Supreme Court,
Yes.
petitioner should have been a lady. Collected him.
This is recently as in S. Madhusudan Reddy also, madam.
Judgment from the Apex Court.
Yes, this is
Para 45 or 65, something I just, but 45 also.
in fact in Kamalesh Burma also it is clearly said, madam. The review cannot be filed on the same ground of writ petition or.
In that particular judgment of the Kamalesh Burma, whether the earlier decision, the Apex Court has been cited.
No, but sir, judgments are cited, my lord. And
Just pass on, I'll just get it.
Yes.
If it is that, 45 or 55.
No. Yes, my lord.
Just pass it on. Just Lily Thomas,
Yes, Lily.
Lily Thomas does very clearly. Course, Lily Thomas has many cases. Out of
Yes.
that one, in one of the Lily Thomas, Apex could clearly lay down.
It's para 16, my lord. If two views are possible,
No, no.
it cannot be ground. That is one other aspect, my lord. Lily Thomas, my lord, 2006 SCC 226. It's the amount of Lily.
Nothing.
Hmm? But para 17 of the Kamalesh Bama, para 17. You know, in a review petition, it is not open to the court to reappreciate the evidence and reach a different conclusion, even if that is possible. Now, my lord, here apparently, my lord, even though it is possible, we cannot do that in a review jurisdiction. Conclusion arrive at an appreciation of evidence cannot be assailed in a review petition unless it is shown that there is an error apparent to face of the record or for some reasons akin thereto. In summary, my lord, your lordship will find it is clearly said where review will be not maintainable. At para 20.2, my lord. So either of these, a repetition of all and overall argument is not enough to reopen the conclusive adjudication. So what my learned friend is arguing, it's the same argument which was made in the repetition. So that cannot be a ground of review. Minor mistake of inconsequent import, that is not the case. Review proceeding cannot be equated with the original hearing of the case. So we have to rehear the case if, my lord, we have to reverse the opinion of the or judgment of this court, my lord. Review is not maintainable unless the material error manifests on the face of the order, undermine its soundness, or results in miscarriage of justice. A review is by no means an appeal in disgust, whereby an erroneous decision is reheard and corrected by lies, but lies only for the patent error. So if he is not satisfied with the judgment, he will have to approach before the apex court. Then the mere possibility of two views in the subject cannot be a ground for review. So he is saying, my lord, their argument is that the view taken by this high court by the division bench is not correct. It could have been taken in other way, my lord. That cannot be done in the review. Then, my lord, point number 9, review is not maintainable when the same relief sought at the time of argument, the main matter had been negative.
Third, Mr. F.U. Hawk, and counsel for the
M.U. Ahmed, my lord.
M.U. Ahmed.
M.U. My lord, my simple prayer was for equal justice and equal treatment, my lord. One hand, yes, similarly situated case allowed by the Honorable High Court on the same grounds, it was rejected, my lord. So the present petitioner is as a last
Mr.
forum, my lord, has approved before the
Did I-
Honorable High Court.
Standing Counsel, Home Department. For the respondent number 2. 5. Also heard Mr. A.I. Ali, Standing Counsel, Election Commission of India. For the respondent number 3.
Yes.
And Mr. Karket Alunda, Government Advocate Assam, for the respondent number 6. A coordinate bench. By an order dated zero 2018. In WPC number 5882 of 2018. With regard to his brother Hamid Akan, allowed the repetition by order of the election, allowing him to file permitting him. Not allowed. The additional written statement and additional evidence in chief with the condition that the same is done on the very next date that was fixed on 18/09/2018. It is submitted by Mr. Mahmood that the same coordinate bench with regard to the petitioner in his WPC number 6075/2018 by order dated 07/09/2018 rejected his prayer enabling him to file additional written statement and additional affidavit in chiefs. It is placed before the court that two foreigners tribunals case under the Foreigners Act 1946 before the same foreigners tribunal, i.e. the foreigners tribunal retained Borpeta, were under process against the petitioner, i.e. FT case number 152/2017, and against his own brother, being FT case number 162/2017. Both the cases were fixed before the same tribunal on the same dates. And on the same dates, they took time they are engaged counsel on a later date, file application, individually file application. To permit them to file additional written statement and additional evidence in chief before their cross-examination. And the tribunal, by two different orders in those two proceedings on the same date, rejected same date, I on 21/06/2018 rejected such prayers of the petitioner as well as his elder brother, his brother. Hamid Akan, for which they filed writ petitions being WPC number 5882/2018, in bracket Hamid Akan versus Union of India and 5 others. And WPC number 6075/2018, in bracket Saha Ali Akan versus Union of India and 5 others. By order dated 06/09/2018, the said coordinate bench allowed the writ petition WPC 5882/2018 preferred by his brother, whereas by order dated 07/09/2018, the said coordinate bench rejected the prayer of the petitioner to vote
The petitioner as well his brother will represent by the same counsel before the court. And this review petition seeking for equal justice. Mr. J. Payam, counsel appearing for the state respond. Submitted that. Petitioner filed this review petition on 20
25, 11, 22.
25/11/2020. After
Calculated is 524 days.
for review of the said order, it is 0709/2018. Past date. WPC number 6075. After more than 520 days, 524 days, without explaining any delay in preparing the said review petition. It is also submitted by Mr. Pang that the three conditions precedent required for review of an order as specified in the order 47 of the Code of Civil Procedure has been failed to be established by the petition. The review. Further, Mr. Pang relied on the decision of the Honorable Supreme Court in the case of Lily Thomas versus Speaker, no, Lily Thomas versus Lily Thomas and others versus Union of India and others reported in 2006 FCC 224, as well as Kamalesh Verma versus Mayawati and others reported in 2013 8 FCC 320. Nikhil, Mr. Mother, placing reliance on the judgments of the Honorable Apex Court. Submitted that there is no such valid ground for review of the said order. It is 07 passing the WPC number circumstances. And accordingly, submit for dismissing of the review petition. On being inquired, on being asked, Mr. M.U. Ahmed, learned counsel appearing for the petitioner, submitted that only for equitable justice, the petitioner has filed this review petition as the same court, the same coordinate bench earlier allowed the case of the petitioner on the previous day. And the next day rejected his case. Though both the cases were argued by for the petitioners by the same counsel. List on (26/0) 4/2024 for necessary order. We'll pass the order. Published. Yes, which item you ready with? Will argue today?
My lord, any other bill.
Yes, next. You are arguing today? You are appearing for whom? Which item?
I mean, item
10. Who is for 6? No representation, less than a name. Yes, Mr. Mahmood.
My lord, I had some urgency item 11. Maybe that is review petition. After hard struggle, you have got this bench.
True.
So if,
Come back at 2 o'clock.
But your lordship, it was been adjourned by the respondent, so.
wait,
uh,
what is what?
Oh, Mr. Bora mentioned it in your presence only,
তুমি আসলে
taking for another date.
তুমি আসলে তো কি objection?
You were there. Mr. Asbora who submitted for adjournment in your presence.
Oh, it's a great objection.
You did not object at that point of time.
Then already a short date may be fixed if she has taken a date. Because this is of
Just
this,
a minute,
they
just a
only
minute,
this
let
bench
us-
can take up.
Let us-
Yeah, I,
need to- Wait any moment.
objection क्यों दिया नहीं?
We can do one thing,
बोलो
25th, 26th. You can sit on 25th and 26th. If you are talking-
25th.
See, 26th again, there are elections, councils, some of the districts, there are elections.
That is
Councils.
26.
26 is the election,
Ah,
that is the reason. See, we will be sitting not only for your purpose, but we will have other cases are there. the
that's why
reason.
well,
Or at best, we can fix it on 9th and 10th, safest,
May.
May.
We have
9th
the-
is Thursday, after the election is over on 7th, 9th and 10th.
10th.
9th will, if we need to continue, we can continue up to 10th.
Well, so far item 1 is fixed for judgment. And
that will
2 and 7 may kindly be taken in another day. Man.
So we'll fix these matters on 9th,
All this matters.
on 9th.
Yes.
Right.
2, 7 and 11.
All-
Obliged.
Mr. Goswami? Who is in the other side?
Mr. Kamuli, I have not seen him, my lord, outside also. He's not present, my lord.
We have it on 25th.
Well,
We're passing this order on 25th. We'll hear
Well.
you on 25th. তো 25 তারিখ পরীক্ষা। Go to query 45 election, huh? 26th পরীক্ষা। We'll have it on 26th.
My lord,
Welcome to take. দুইটোতো তিনিটোতো হৈ গ'ল 2, 3, 5, 6, 7 গোটেইখিনি কৰিলো 8 কৰিলো 8টো ৰিভিউ পিটিশ্যন who is appearing for 8 good সব 9 ত কৰিলো এজনমেন্ট বিচাৰিছে তো 9 টো 10 11 let it be 9 better
More 10, more to urgency. I have urgency 10th, I will ergo today.
we'll have it on 9
On
9th
Lordship, if possible, there is ground for review, good ground already other side has gone into. Then I will pray for,
which item
I will pray for issue of notice and stay of impugned judgment because
notice have not been issued
no, not it issue. Other side have already gone through the petition. We have fulfilled all the 3 criteria.
Oh.
Everything. The newly discovered documents and the earlier documents also not real. I have annexed 3 judgment of this coordinate bench and relying some FX court judgment also.
okay
It's a good case for review. Ground starts as page 18 onwards. Lordship may have looked at page 22. Because forefather, grandmother,
Mr.
father,
Islam, counsel appearing for the petitioner
everyone is Indian citizen.
and Mr. Z. Sharma, standing counsel, Home Department, Assam, for the respondent numbers 2 and 2, 3, 4. 2, 3, and 4. Also heard Mr. R.K. Talukdar, Government Advocate, Assam, for the respondent number 5. Issue notice returnable by 9th May.
Lordship, prayer is at base 44, 45. At least orders may be staged for the time being. In the meantime, otherwise police is
Petitioner shall
starting.
have requisite extra copies of such and such to Mr. R.K. Devchuri NSDN for the respondent number 1. Baki kita milai di
9th of May, Lordship.
on or before.
9th of May, I can't thereafter or before.
What's the date?
9th of May, I have engagement in other court. Thereafter only.
By 4 weeks. Good.
Yes.
Date native. On or before 25 obtaining the acknowledgement from the event.
In the meantime, Lordship,
Interim priority petitioner shall be considered on the written application.
Thank you very much.